some reason we seem to be having a technological problem. The right to privacy is quite a difficult topic to handle in law. Although we all recognize privacy, privacy is one of the most difficult terms to define in law. And that has created a lot of problems, and that's one of the reasons why there is so much debate and discussion about whether the Supreme Court of India is right in saying what it said in that judgment. And I'll explain to the extent possible why the difficulty arises. Generally speaking, in most common law countries, there is no discrete right to privacy. In other words, there is no distinct, separate, standalone right to privacy. That does not mean the law ignores privacy. On the contrary, the law protects privacy through other causes of action, which I'll refer to as we go along. But directly, there is no freestanding right to privacy in most countries. And that's the case with India as well. There's also a difficulty, if you don't have a right, then sometimes you'll find it difficult to have a remedy. So, a remedy for lack of or invasion of privacy has also proved problematic. And that can be illustrated with the case of Kay and Robertson, which is an English case, where what happened was, Gordon Kay was a famous film actor. Some of you may be aware of a BBC television series, a comedy series called Allo Allo. I don't know if you have seen this. This was broadcast about 20 years ago, in which Gordon Kay was a key actor. He was a leading actor. Now, this case does not have anything to do with his acting career, but it was something to do with his personal life. Now, Mr. Kay was driving from A to B on a day when there was a massive storm in England. This was in October of 1986, when many houses were swept away, many trees fell, and all kinds of chaos ensued on the streets. Mr. Kay was driving, and to his misfortune, a huge tree fell on the windshield of his car. And unfortunately also, a branch of that tree went through the glass and went through his head. It pierced his head, and it caused serious brain damage. Mr. Kay was admitted to hospital. He was in and out of consciousness. It was a very serious injury that he suffered. But he somehow pulled through, but had to spend many months in hospital. While he was recovering in hospital, one of our tabloid newspapers took it upon itself to interview Mr. Kay. I use the word interview in inverted commas for reasons which will become clear to you shortly. What the newspaper did was, it sent a reporter and a photographer to Mr. Kay's hospital room. They went and sat by his bed and started talking to him. They told Mr. Kay before they began that they are from this particular newspaper, that they are interviewing him. And the photographer took pictures of Mr. Kay while he was talking. They ended the conversation, went back to the office and wrote what they thought was a good front page exclusive. And they actually did give it the caption, "Exclusive interview with Robert Kay." And they published the interview. I have to say at the outset that everything that was published was entirely accurate. They did not make up anything. Everything was properly reported. Questions, answers, and there were pictures. Pictures were not distorted. When the interview was published, Mr. Kay was very upset. He was upset because he did not think that the interview should have been published. Now, he instructed his lawyers to do something about it. Do you think the lawyers could have found a way of vindicating Mr. K's objections to the interview?
Did he consent to the interview in the first place?
Beg your pardon?
Did Mr. K consent to his interview being taken in the first place? That means he would have agreed to whatever was going to come out, which means he was aware of what he was telling the reporter, and he was aware that the photographer was going to take pictures of him, even if he were in a, say, plaster cast or in the hospital beds. So then, I don't see how an issue can register in the first place.
Well, I start with the point you made at the beginning of what you said, namely, was there consent? The newspaper would argue that there was consent. In other words, that he consented to this interview. But do you think that argument will win?
So should the mental state of the person taken into consideration? Consider that he is in the hospital, most probably on drugs. Like his permission, he can actually invalidate his own permission later on, saying that I was not in my perfect state of mind.
Yeah, you are on the right lines. I wouldn't go so far as to say he can invalidate his own permission. I would put it slightly differently, but you're absolutely on the right lines. What really happened here was that although Mr. K was able to talk, he was in and out of consciousness. So this is one of those rare occasions when a person is not fully of alert mind. It happens because of the nature of the injury. So his consent, again put it within inverted commas, was not genuine consent to the extent that the law recognizes full informed consent. And so he had not given full informed consent.
In many normal cases also, the person said later that yes, I gave the interview, but you are not for the publication. It was a general understanding, I just said something, but your reporter didn't take any consent from me for publication.
He cannot say that
Sometimes,
afterwards. He can say that before he gave consent. He can say, what I am telling you is off the record, no problem. But he has to say it before, not afterwards. Okay?
So whatever he said in the interview was published end to end without any editing or whatsoever.
Well, there would have been some editing for language, because you know how it is in any interview, even if you are a very articulate person, there can be slips of tongue.
So then he can argue that the interview was edited in such a way that it made it infringes privacy.
No, he cannot argue that because the newspaper was very careful not to engage in over-editing or distorted editing. In other words, what they edited was totally reasonable. So that argument is not valid. But the argument that was made about consent is very valid. So eventually what the court said was that what he gave was not fully informed consent. There was an element of consent in the sense that he was able to at least see these people, talk to them, etc., etc. But it was not of a kind that the law would require any person to give. And so what happened here was that because there was nothing untruthful said, he could not sue the newspaper for defamation. For defamation, you would have something false. Everything that was said was true, even though he didn't like what he said. So what the lawyers did was, they came up with the idea of suing the newspaper on malicious falsehood, injurious falsehood. The falsehood being that he gave an exclusive interview. He did nothing of the sort. It was never his intention to give an exclusive interview to this particular newspaper. So if you put that big caption, then of course you're misleading the public. It is a falsehood, and they knew that it was a falsehood. So what then happened was that they had to pay damages to Mr. K for that reason, and also because they made a profit out of this interview. This is very important to remember, because the tabloid newspaper, they published it, many copies were sold, so they had to pay damages, but not for defamation, for malicious falsehood. And there is no such thing, or at least there was no such thing at that time in England, as invasion of right to privacy as a separate head of legal action. So you can see the difficulties there.
Does it see any other newspaper carried?
No,
Then
only this paper.
it became exclusive for that newspaper.
that is not the point. The point is you give the impression that this man had commissioned an exclusive interview with the newspaper, which he never did. In fact, his intention was exactly the opposite. So you can't put words in his mouth, or you can't make it seem to the outside world that he somehow cooperated with the interview.
But normally, sir, we classify the nature of the interview, not the interview.
You classify the
Nature of the interview. No.
Well, if you did that, you take the risk. Because if you classify it wrongly as exclusive, then of course you run the risk. Now the point is, when you do an exclusive interview, you normally get a consent form signed from the person. Suppose you're interviewing Shah Rukh Khan, and Shah Rukh Khan has given you an exclusive interview. Then normally there has to be a very clear agreement signed between the parties, where Shah Rukh Khan says, I am giving this interview to you exclusively, because otherwise he'll go and give the same interview to someone else, in which case your newspaper will lose money. And he wants protection as well, so he would put many things in the agreement which you will have to sign. So for an exclusive interview, there are many things to be gone through, none of which this newspaper went through. It did not seek agreement.
We don't have that kind of agreement.
Well, the whole purpose of these classes is to make you understand how it is done in other countries, and if you feel it is useful, you should use it as good practice within your systems, because otherwise, with the expansion of the media in India, there's a fair chance that what you think is an exclusive interview for you will be taken by other people. So you need to be careful. Okay, right. There was a hand up there. Okay, all right. So that was the Gordon K case. Now, what are the actions that are normally used to protect privacy in countries like England, and even I would say to a large extent in India? Trespass. When do you use trespass? Suppose you are a journalist and you go and take pictures, or you go and seek an interview with someone by going into their premises, so into their homes. Now, they can sue you for trespass because you entered the property without permission. It is very rare, but it is possible. Nowadays, of course, journalists are smart. If they want to take pictures, they don't enter people's property and take pictures. They take pictures from outside using a telephoto lens. But there have been occasions when people are trespassing to other people's property. So trespass is one of the heads of action. Harassment. Now this doesn't quite apply to India, because India does not have a distinct law on harassment of the sort that you have in England. In England, there's a law called the Protection of Harassment Act, under which if you do something that causes alarm or distress to another person of a certain standard, and you do it more than once, in other words, you repeat such conduct, then you are liable for harassment. And you can, the court can give an injunction saying you should not go anywhere near 50 yards of a person. This is mainly intended to discourage paparazzi. When they go and take pictures very close and sometimes even hurt the person they're taking pictures of. And this law was used very effectively by Diana, Princess of Wales, in England in many cases, because there were journalists constantly harassing her. So harassment is a possibility, though not, as I said, in India. Defamation is possible, but defamation is only possible if what is said is false. And then nuisance is also possible, but that is extremely rare, where you can seek action against, for example, a whole bunch of journalists committing nuisance on your property. If that happens, that also can be a ground of action. Copyright, very interestingly, is one way in which you can defend your privacy. And I'll explain how when I deal with a particular case. Sorry, is it getting too cold? In which case, can I simply raise the temperature, because I do want a certain degree of coldness, if you don't mind. Copyright is something which can also be used to protect privacy. I will explain that shortly. Data protection, also not available in India, not yet available in India. There is a move to making a data protection law. There is a committee that's been constituted recently which is going into this issue. And breach of confidence. Breach of confidence is the most useful cause of action to protect privacy. And I'm going to be spending a fair bit of time explaining to you what is breach of confidence. And of course, there are various contexts in which privacy can become relevant. So you will have media intrusion or investigative journalism, where sometimes you carry out sting operations. That would clearly be an example of invasion of privacy. Surveillance and searches, including interception of communication. Sometimes interception of communication is carried out by the media as well, not only by the state agencies. There have been many occasions when journalists have used high-tech equipment to intercept communication between parties. And sometimes they do it with the collusion of telephone engineers. Then there is disclosure or leaking of private information, the control of the state, and there you get issues like Aadhaar, which I'll briefly talk about, but it's not strictly speaking part of media law. It is definitely an element of privacy, but not necessarily connected to the media. Medical records, yes. Sometimes journalists surreptitiously try to obtain medical records of people they are investigating. And that again is an invasion of privacy. We have to look at what are the circumstances under which it is permissible and not. Use of intrusive medical procedures, polygraph tests, again not relevant to the media as such, though of course journalists can sometimes be subjected to those tests themselves, but otherwise it's a more general invasion of privacy. The point I'm trying to make is, privacy is such a huge topic, in addition to being a topic that cannot be precisely defined. The term itself, privacy, cannot be precisely defined. So it would be very difficult to deal with the entire topic. I'm only going to focus on privacy as it applies to journalists. That is the purpose of this course, and therefore I'm going to deal with privacy in the aspect of its effect on journalism.
So since you're talking about harassment as well, I was wondering whether there is a difference in, say, the extent to which I as an individual can claim my privacy vis-a-vis a celebrity who can claim their privacy because they have been in the spotlight for much more period of time than I have, and they also, I mean, it's a part of their profession. So do you think that there's a difference in the threshold of privacy that can be claimed between an individual citizen and a celebrity?
Okay, the short answer is in practice yes, but in principle probably no. And I'll explain that when I deal with cases. But it's a very important question, which I'll come back to. Okay, so those are the introductory remarks I wanted to make in relation to this topic. Now, as I said, it is very difficult to define privacy. You either have a situation where the definition that you attempt is too broad, or you're in a situation where the definition is too narrow. What are the definitions that have been attempted? I'll just give you a few random examples. The most common definition that people speak about when talking about privacy is the right to be left alone. Now, as a slogan, as a catchphrase, as a mantra, it sounds good. But in law, it creates huge problems. Nobody has the right to be left alone. You can't say, for example, to a policeman who stops you for violating a traffic rule, no, leave me alone. Sorry, there is no such thing. Or you cannot stop the CBI when it's inquiring into something serious, that you should be left alone. So the right to be left alone is all right as a general slogan, but in practice it has problems. Then there was a definition given in an Indian case in 2003, which is the stage of being free from intrusion or disturbance in one's own private life or affairs. This is a slightly better definition than the definition of being let alone. But it still poses problems, as we'll discover when we discuss the cases. And of course there's a definition from the dictionary, which is the right to be free from intrusion into or publicity concerning matters of a personal nature. Again, that is a very general, workable definition. It is something which we need to keep in mind, but it is not, in legal terms, a foolproof definition. And of course, when you talk about the concept of privacy, you normally accept the concept as covering a person's body, home, property, correspondence, etc. And of course, you have inevitably the concept of personal autonomy being brought in the context of privacy. So if you read the Supreme Court judgment, the word autonomy appears ever so frequently. And it's also associated with personal dignity. This is another word which features very strongly in the Supreme Court's judgment. Now, how did the right itself evolve? Clearly, if you go back in history, in a sense, the starting point in modern times was the invention of the printing press, when it was possible to talk about someone and disseminate that information on a wide scale through the press. Today, of course, it sounds quite old-fashioned and quite limited, but it still at that time was a remarkable breakthrough, because till then you did not have a medium through which you could disseminate information about other people at such a large, on such a large scale. And then, of course, you began to have photography, then long lens photography, and various other sophisticated techniques, listening devices, which have now become very sophisticated, so much so that you can sometimes listen to conversations a mile away. That's the sort of thing that you have now, and of course computers, which have remarkable capacity to invade a person's privacy. And of course, what used to happen in the past was that the concept of privacy was always linked to the concept of property. And so you had prohibitions against government searches of premises. Because when the government searched your home or your office without permission or without warrant, then that was seen as an invasion of privacy. So the concept was linked strongly with property. And the US Fourth Amendment, which is quite a strong statement of law concerning privacy, was also brought into aid in that context. Then you had other instruments like the European Convention on Human Rights. But then the focus shifted from property to the person. In other words, privacy became more attached to a person, an individual, rather than to property. And that is reflected also in the Supreme Court judgment. And you began seeing, at least in some jurisdictions like the UK, the acceptance of a standard which said, which talked about a reasonable expectation of privacy. In other words, what are the circumstances under which you can go to court and get your rights asserted? You can do that when your reasonable expectation of privacy has been belied. And there are two main causes of action: breach of confidence and misuse of private information, both of which I'm going to talk about now. Breach of confidence is clearly the most important legal technique for protecting privacy. Now, there are two different types of breach of confidence. Historically, this action has evolved. So if you look at the traditional action, it covers trade secrets and some forms of personal information. So if you were working for an employer and during the course of employment you learned certain things which are confidential, there was an expectation that you will not reveal those things when you have left the employment. And even today, that is the case. So if you work for a certain company and the company deals with certain products or services, you get information of a confidential nature, you leave the company and join a competitor, you cannot disclose the information you got from the first employer, because that would be a breach of the confidence that that employer had placed in you. So breach of confidence in that context is what was at the root of it all. Similarly, it is possible to argue,
Sorry to cut you there, but since we're talking about employment and trade secrets, right? So is there any sort of time limit that's placed in practice with respect to the employee not revealing the secret? Say for instance, I move from MNC A to B. Right now, information that remains valid and say can cause harm to the company for a period of 3 years after I've left employment makes sense, but something like say 5-7 years becomes unreasonable then, right? So in practice, is there any time limit imposed?
Yes, not only time limit but also territorial limit, geographic limit. So if you were working for a firm in Calcutta and you learned certain things from the firm, you would almost definitely be able to use that learning or that information if you were working, say, in Trivandrum. because the audience is different, and secondly, the clients that you are addressing are going to be very different. So territorially as well. Usually the contract of employment will say that you will not be allowed to reveal any secret for 25 miles, for a radius of 25 miles, 50 miles, 100 miles, or whatever. But time, yes, it can't be indefinite. But there are certain occupations where it is for life. There is no, it's not time bound. A very obvious example would be if you're a nuclear scientist, right? Mr. A.Q. Khan has had an obligation which unfortunately he breached of confidence for life. He could not reveal what he learned about the Pakistani nuclear capability for the rest of his life. In those circumstances, obviously, if he did, and if the Pakistani legal system was strong, then he could be the subject of legal action. So the short way of dealing with your question is to say yes, there would be limits on time and distance. Now, there were three conditions which needed to be satisfied for invoking the concept or the action of breach of confidence. First of all, that the information must have a quality of confidence. This obviously varies from case to case, but there has to be a degree of confidentiality attached to the information. It should not be trivial information. It should have been communicated in circumstances imposing an obligation of confidence. In other words, there is, even if it's not written down on paper, there is an understanding that what is being said is said confidentially. Thirdly, there must be an unauthorized disclosure of the information. Now, I'll give you another example which is in the domestic context. You know that between husband and wife, very often there are many pieces of confidential information exchanged. Now, what if after a divorce, the husband sold his story to a newspaper because he gets a lot of money and he says some salacious things about his wife, for example, about their sex life. Now, that will also be covered by breach of confidence, even though there is no written contract. A husband and wife usually don't put it in writing that when they divorce, there shall be an obligation of confidence, etc., etc. But it is understood because all the three ingredients have been satisfied. So it's not only in the commercial context, it can also be in the domestic context. Now, how did the concept develop? You had a liberalization happening. First of all, there was a relaxation of the need for an initial confidential relationship between the parties. In other words, the parties did not have had a defined relationship. It didn't have to be an employer and employee, husband and wife, etc. It could be just two independent parties. And this applies to newspapers as well, as we'll discover when we look at the cases. Also, the extended action, the rule requiring information to be confidential was changed to a rule which required information to be private, because it is possible sometimes for information to be considered private rather than confidential. And now I don't have the time to go deep into this, but just keep this in mind. It is possible to make that distinction. And also, the extended action now covers unauthorized publication of information that the recipient knows or ought to know is private. This affects journalists. So, for example, if a civil servant comes up to you and says, you know what, I'm going to tell you something about India's nuclear secrets. Now, you'll of course be delighted as journalists to get that story. But you will be very naive to assume that that information can be published. Why? Because even though you don't have an existing relationship with the civil servant, even though the civil servant doesn't say this is confidential, it doesn't say so, you have to assume it is confidential, given the nature of the information. And therefore, if you went ahead and published it, you will be running a risk because you did something that is clearly not right, according to the law. At least you ought to know it's not right. So there's a presumption in law about these matters. Now, clearly there's a balancing exercise to be worked out between freedom of expression and right to privacy, and that is usually the dilemma that lawmakers face. Where do you draw the line? As journalists, for you, freedom of expression is very important, and you may want, on occasion, to breach somebody's privacy on the larger principle of freedom of expression. And of course, high weightage is normally given to freedom of expression, particularly in a democracy. And there is the influence of jurisprudence from Europe, which also stresses the importance of freedom of expression. Now, I want to talk a little bit about the Indian Supreme Court's approach before I begin to deal with the cases. There are a couple of cases which go back to the 70s and 80s. In particular, there is a case called MP Sharma and there is a case called Karak Singh. These two cases dealt with different aspects of privacy, and those two cases are dealt with at great length in the Indian Supreme Court judgment. But in a very real sense, the right to privacy began engaging the attention of the Supreme Court. The right to privacy in the 1994 case of Rajgopal. Now what happened there was, again I won't spend too much time giving you the facts, but essentially there was a fellow who was convicted for many murders, and he was known by the popular name, the nickname of Otto Shankar. He's a South Indian fellow, and he at one stage, while in jail, decided to pass on information about his life and allow a magazine, a Tamil magazine, to publish his life story. Basically, his autobiography in various parts. Except that when the publication was mooted, an attempt was made by the jail authorities to get an injunction against the publication. And they compelled Otto Shankar to sign a confession, to sign a statement which seemed to indicate that he was not willing to allow the magazine to publish. Actually, he was willing to, but they compelled him. Why did they compel him? Because it seems that a lot of these officials had actually colluded with Otto Shankar, and if Otto Shankar had come out with the facts, they will all be in deep trouble. So they all tried to use the fiction of the right to privacy by saying if the magazine published Otto Shankar's life story, then his right to privacy would have been invaded. In other words, they're taking the high moral ground when all they really wanted to do was to protect their own personal interests. So the matter went to the Supreme Court, and to cut a long story short, what the Supreme Court said was that no one could publish anything about a person's family, marriage, procreation, motherhood, childbearing, education, etc. without their permission, unless he voluntarily thrusts himself into controversy or invites or raises a controversy. Now this means that, if you read it literally, it means that if you're a person who's never been in the public limelight, then you can keep all your personal affairs completely to yourself, that nobody can write about you. It is not easy. I personally find this judgment very troubling, because what do you mean you can't write about someone's motherhood or someone's education, etc.? A lot of it is, I think, innocuous information and should be allowed to be written about. Suppose you were to write about someone that he was such a poor student, he failed all his exams in school. What's wrong with that? As long as it's true. If it's false, of course, the person can sue you for defamation. But if it is true, why not? Yes, sorry.
Sir, even in the privacy judgment, sir, even though they don't mention these particular grounds, but the way it's written, don't you think all of this gets included in the judgment too?
It probably does. Everything depends on how the judgment is interpreted. I agree with you.
But sir, if you interpret that along with this, because like effectively past the judgment have also like upheld Rajgopal, so if you interpret,
You don't have to now go back to this judgment at all, because the latest judgment covers everything. They say that this is the final word so far on the right to privacy. Okay? And that final word is not very clear.
So, but the problem is that with the 9-judge bench, they have validated all judgments that upheld the right to privacy.
yeah, they
Right?
have referred
Which
to
means
Rajgopal.
that Rajgopal is valid as compared to MP Singh and MP Sharma and Karak Singh, which were expressly overruled.
Not fully, most of it, or part of it were. But anyway, that's not the point. The point I'm trying to make is that yes, it is true that these things are still valid, but you don't even have to go back to them, because now you have a so-called comprehensive statement of the right to privacy by a 9-judge bench. I personally disagree that it's a it's a judgment that gives great clarity. On the other hand, it leaves a lot of questions to be answered. But we don't have the time to go too deep into that. I'll deal with the judgment shortly, very briefly. But the point is, yes, all these things are still relevant to that extent. All I'm saying is that what happened in this case was itself a bit wishy-washy. So that's what it said. And then, of course, it said it would not be a breach of privacy if the publication request was based on public records or if related to a public official in relation to his official acts. Now, up to a point that makes sense. But what if you did not rely on a person on public records, but you wanted to talk to a person's friends about his education? That would, of course, be considered a breach of privacy if he is not a celebrity, if he is not someone who is in the public eye. I personally think that the bar has been set very high, and it would be an infringement of freedom of expression. But that's my personal opinion. It's possible that you have a different view. And as I said, there was a more authoritative pronouncement in the latest judgment. Now that judgment is this thick, 574 pages. I personally think what they have said in those 574 pages could have easily been said in 174 pages. So it's about 400 pages too long. But never mind.
This is the ninth judgment.
Correct.
The recent
Yeah. Okay. So if you are brave enough, please do read it from cover to cover. Okay. And there's a lot of repetition. There's a lot of vagueness, etc., etc. But never mind. It's not my job to analyze that judgment at such length. I don't have the time anyway.
So there are addendums by individual judges also?
Not addendums. Don't talk about addendums. They'll feel very offended. Very original contributions from each of those judges.
Those are included.
There's first a judgment consisting of 4 judges, and then there are individual judgments, 4 I think, 4 and 5, 9 judges. Yeah, that's how it is. Okay. So everybody likes to get their 15 minutes of fame, so they want to add their own things, even if what they're saying is either completely, I'm struggling for a word, let's just say not particularly enlightening, or it's a repetition of what the other judges have said. But anyway, that's for you to look at. I just want to give you a brief summary of what emerges from this judgment. The first thing is, the judgment repeatedly talks about the right to privacy being part of the chapter on fundamental rights, and in particular being part of Article 21, which is, for our friends who may not be familiar with the law, the right to life and personal liberty. That's what Article 21 is all about. Now, I'm not poo-pooing the idea. Clearly, privacy is an aspect of personal liberty. But all I'm saying is, for it to be given this kind of exalted status and to be repeatedly told it's a fundamental right, when the constitution makers had expressly, after giving it due consideration, rejected the idea of putting it as a fundamental right, I think begs questions at the very least. But they use it like a mantra, saying it is part of the fundamental rights. And what is more, they say, although they refer to Article 21 a lot of the time, they say it also comes from other articles. Now you need to actually be clear what are the other articles from which it comes. Be very precise, because remember that every fundamental right allows for reasonable restrictions to be placed. Suppose you say that the right to privacy is only derived from Article 21. Then you can also look at the permissible heads of restriction under Article 21 and say that those heads apply to restrictions that can be imposed reasonably to the right to privacy. But if you say vaguely, it could be any other fundamental right, then there can be trouble, because different fundamental rights have different heads of permissible restrictions. So there's a legal issue there. Also, the judgment has pointed out to a very strong connection between the right to privacy and human dignity. This is something I've already spoken to you about, and there's in principle nothing wrong with that. That seems to be a very sensible thing to say, in addition, of course, to the right to freedom. Privacy is deemed to include at its core. In other words, they're now trying to give some guidance as to what is meant by privacy, without attempting to define it comprehensively, because I think the Supreme Court judges will also realize that they cannot provide a comprehensive definition. So what they're saying is, at its core, it consists of the preservation of personal intimacies, the sanctity of family life, marriage, procreation, home, sexual orientation. The sexual orientation bit is a new one, and it is definitely intended to give out a signal to the bench that is going to decide this case subsequently, because if you see Rajgopal, there is no reference to sexual orientation. You could say it is implied, but the fact remains that this is definitely a signal that the Supreme Court has expressly chosen to give. And privacy is not lost or surrendered simply because the individual is in a public place. In other words, even if you are seen in a public place, if what you are doing is intended to be a private act, then you preserve your privacy. That is something which, in general terms, is an acceptable proposition. If you take an extreme example, you know that in India, very often you hear criticisms about the fact that the level of sanitation is so poor, so low, that many women have to go out in open fields to defecate. Now, it's very sad, but it is a reality which is being reflected in a lot of writings. Now, they are in a public place. What if a media photographer took pictures of them in those circumstances? I would argue that this proposition would kick in. The fact that they're in a public place does not mean they lose the right to privacy. And what they are being photographed in is definitely an act, a private act, which entails an expectation of privacy on their part. So, to that extent, I would agree with that formulation. And in relation to informational privacy, the government has been urged to put in place laws which have their legitimate aims. Now, what's happening here is the Supreme Court is telling the government it's about time you passed a law for informational privacy, and what that law should be, they're giving guidance. And the guidance says that it should have as its legitimate aims the protection of national security, prevention or investigation of crime. Surprisingly, they have not mentioned detection of crime. Detection of crime is a very important aspect. They seem to have ignored that. Encouragement of innovation, spread of knowledge, and prevention or dissipation of social welfare benefits. The last one, I think, is a signal to the bench that is hearing Aadhaar to say, look, don't worry, don't assume that Aadhaar by itself is an invasion of privacy. Probably. So there we are. That's, I think, the main features of the latest judgment. Now, I want to move to something more directly relevant to you as journalists and bring the focus back. Because if I were to deal with this judgment, we'll be all over the place. Because this judgment talks generally about the right to privacy, not about the right to privacy as applied to journalists. And my focus is clearly the media aspects of privacy. So, legality of sting operations. A sting operation, as you know, is a deceptive operation which is aimed at exposing crime or other unacceptable behavior. Now, what other unacceptable behavior can be covered is a matter of some discussion and debate, but it should not amount to entrapment, that is provoking an otherwise law-abiding person to commit a crime. The dividing line between entrapment and legitimate sting operations is a very difficult one. And there's so much case law, particularly under American law, where cops do something and then they discover somebody has committed an offense. The argument used by the accused person's lawyers usually is that the cops made the person commit that crime, which he would otherwise not have committed. So it's quite a difficult area of the law. We don't have the time to go into that, but entrapment is something which needs to be borne in mind. Sting operations may be justified by overwhelming public interest. What they are, I'll describe shortly. The general point I want to make is sting operations are legally very dicey. Quite frankly, they are impermissible under law. But if you can show strong public interest, you could be excused for violating the law when it comes to conducting sting operations. But the onus is on the publisher. In other words, it is on the media to show that there was strong public interest, not for the affected person, the victim, to show that there was no public interest. And there must be a clear demonstration of how the public interest should be served by publication. So those are the things that needed to be done by the media. Now we come to the very difficult area of public interest. I've already told you that an important principle to be borne in mind at all times is that simply because something is interesting to the public does not make it a matter of public interest. Very, very important. There's a difference between what is interesting to the public and what is in the public interest. So that, for example, sex might be very interesting to the public, but it's not always in the public interest. Or violence, gratuitous violence. So you need to keep that in mind and then to move on. Also accept the risks of sensationalism or voyeurism, both of which cannot normally be justified on grounds of public interest. What are the acceptable ends to which you can put the public interest to? First of all, detection or exposure of crime or serious misdemeanor. So if you suspect somebody to be committing a crime which the authorities have turned a blind eye to, then you, as part of your investigative journalism, may in certain circumstances be justified in conducting a sting operation to expose that crime. Also protecting public health or safety. So for example, if it is becoming clear that in a certain public hospital, doctors are very negligent in the way they perform their duties. So there have been occasions when a surgeon has left swabs or scissors in the tummy of a patient during operations. Now, if that sort of thing comes out and you want to expose it, then a sting operation may be justified in certain circumstances. And of course, a topical example is what happened last week in the hospital, about which you read in the press, where the doctors performing surgery, not surgery, performing a delivery of a baby, nearly came to fisticuffs, and somebody recorded that footage on a mobile phone. Now that is also like a sting operation, and strictly speaking, the person who recorded did an illegal act, but it was justified on the grounds of public interest. So those sort of things can be used when you're talking about protecting public health or safety, preventing from being misled by some statement or action of individuals or organizations. So if somebody makes a tall promise saying that they will give 25% interest on money invested, I'm sure those investment people would be very familiar with that kind of scam. Then, if you carried out a sting operation in relation to that kind of activity, then I think that should be justified by the public interest. So there's quite a lot that can be done in the name of public interest. But before you begin to embark on a sting operation, you need to keep certain things in mind. So what are those safeguards? First of all, exhaustion of internal remedies. So when you want to carry out a sting operation, you have to ask yourself the question, have I exhausted all the other remedies that are available to me? In other words, have I gone to the authorities and reported what I believe to be a crime or a misdemeanor or a threat to public morals or public health? Only after you've exhausted all remedies can you even think about engaging in a sting operation. Though, as I said, sometimes exhausting remedies may not be practical, because the authority to whom you go may himself or herself be corrupt, and therefore in those circumstances going to that authority is not going to be particularly effective. So that's a matter which also needs to be kept in mind. Yes?
So, I think journalists as such would like to exhaust all the other remedies, because if they go to an authority, they might lose the exclusiveness of the sting operation.
That is not justified by public interest, because that then becomes self-interest, and self-interest is not a ground for engaging in sting operations.
So if a journalist gives a message saying that we could have gone to the public authorities but they refer to corrupt, will that be a good enough defense?
Yeah, as long as they can prove it. Not simply say. A journalist can't say, I think all bureaucrats are corrupt, so I won't go to them at all. I'll do my own thing. There has to be some basis. For example, the journalist may have seen previous complaints being ignored or brushed under the carpet. In which case they may say, what's the point in going to that authority, because that authority is either indifferent or actually corrupt.
But then are the journalists and journalists acting as authority by doing so?
Beg your pardon?
Are the journalists acting as an authority by doing that?
No. As long as they act responsibly, no. It depends. Now, some people can be arrogant and say, we know best, so why should we even think about the others? They will have to pay the price. Because ultimately, you have to judge it by a reasonable standard, by a standard of reasonableness. Which means a judge will sit in judgment to determine whether what the journalist has done is reasonable or not.
Sir, actually I didn't follow the connect between the public authorities and a journalist going for a sting operation. I'm sorry, sir.
Okay, suppose I'll give you a tangible example which I've already given in my lecture on contempt. Suppose you have a very strong suspicion that a High Court judge is corrupt. Okay, so one way to deal with this suspicion or this report is for you to go to the Chief Justice and say, I have received credible information that so and so judge is corrupt. And would you do anything about it? Yeah?
Sir, you have a fair idea about the legal system of our country. I appreciate that. With that background in mind and practice, do you think this will ever happen or this will lead to anything, sir? Is it possible?
Well, surprisingly, however cynical you can be about the system, I would say it can happen because I personally know of at least 2 or 3 fairly honest Chief Justices who will go out of their way to deal with such complaints. I won't name them, I won't name
Deal
the
with some
High Court.
complaint or inquiry against his own brother judge.
Absolutely, absolutely. It sounds a
It
little
is a
incredible.
pricing system, sir.
Sir,
No.
maybe 3, 30 years.
Sorry?
Maybe 3, 30 years.
Possible. But
It's
you.
not always about corruption. What is
Yeah.
that they just out of a sheer inertia they don't think to act.
Not inertia. There are many factors. One may be inertia, the other may be that they think their own career may be damaged by by taking action or bringing it to the attention of people on high. And there's also a structural problem here. That is that India's system of disciplining judges is faulty to the extent that the only punishment that can really be given to a judge is impeachment. And impeachment is not a practical proposition for a number of reasons. Unfortunately also for political reasons. Because if you remember a few years ago, there was an attempt to impeach a judge who was very corrupt. Justice Ramaswamy, right, in Punjab and Haryana. Now, it nearly came to impeachment, and the impeachment was lost because the Congress party supported the judge, and they are a majority in parliament. There is a problem there. What happens if that sort of situation develops? In which case, there is no alternative except for the journalist to go and conduct a sting operation. At least the judge will be exposed in the public's eye. Of course, nothing will happen to him in the sense that he will not be dismissed, but at least he'll be named and shamed. Of course, many of these fellows have such a thick skin that naming and shaming may not do any lasting damage to them. But what do you do if the salt has lost its savor? Where will it be salted? That is a question we need to ask ourselves. But I think there is room for a little bit of credibility in certain circumstances. There are small things the Chief Justice can do. If you go and report about a judge that you think he is very corrupt in a certain matter, the Chief Justice can, without kicking up a fuss, take the matter out of the judge's hands before any damage is done. So believe me, there are ways in which things can be dealt with. This may not be ideal. You may want the corrupt judge to be publicly exposed, shamed, anything short of execution carried out against him. That may not happen. But at least the public interest is served to the extent that he will not succeed in his designs in respect of a particular matter. So the point I'm making is that exhaustion of domestic remedies is important, because otherwise what happens is journalists become gung-ho and resort to sting operations as something which is their birthright, which I think is wrong, because journalists can also get it wrong. And I don't have the time to go into this, but you may have heard a few years ago about something called a reverse sting operation. Remember the Naveen Jindal case? So journalists are not angels either, okay? I'm sorry to say that.
So suppose a scene when I have information that certain minister is going to be bribed, okay?
Yeah.
So at that type of situation, what should I do? Should I film it, or I should inform chief minister to alert that minister to not take bribe?
Alert the minister.
No, chief minister, or maybe.
Okay, your information is that the chief minister is going to take a bribe.
No, some minister is.
Some minister. Okay. So what you're saying is, should I go to the chief minister and
alert him, or
no, alert him to the fact that the other minister is going to take a bribe.
Yeah.
Okay. Or what is the alternative?
film it.
Okay. Well, actually, I would be a little hesitant about approaching the chief minister unless you're confident that the chief minister is himself not corrupt and also capable of taking action. There are bodies like the CVC, the Central Vigilance Commission, which are intended to root out corruption. So,
Well, ministers are not falling under the CBC.
at all. Okay, that's news to me. I thought the CVC would have jurisdiction over all public bodies.
They are under Lokpal.
Okay, all right. All right. There will be some authority which I imagine will at least have the moral jurisdiction in such matters. So I would say, yeah, if you're confident that the chief minister is reasonably straight and capable of taking action, then you would, I think, be justified in approaching the chief minister first. That's a judgment that the journalist has to make. It's based on many circumstances. You don't know. Sometimes the chief minister may be completely straight, but he will not take action because of the precarious nature of his power. So the power balance is such that if he takes action against a particular minister, he will cease to become chief minister. That others will effectively depose him as chief minister. It can happen. So there are various factors involved.
That is the most likely chances.
Yeah.
And in that case, I lose my great opportunity to do great things.
Well, you see, this is the funny thing. I'm very sympathetic to what you're saying in terms of your desire for glory. Okay, that is not an illegitimate interest, but it is something which is not, unfortunately, covered by the phrase public interest. Undoubtedly, if you're working for a TV channel, your TRPs matter, and a good sting operation will boost your TRPs very significantly. But that is not part of what the law considers to be the public interest, if you know what I mean.
Suppose that minister is prized for a beach construction.
Yep.
And I had a chance to film it.
Yep.
So, isn't it in the public interest?
It is, but have you exhausted your remedies? Is still the question worth asking. Have you been to an authority that could have stopped the bribe being taken, or if the bribe has already been given, ensure that the minister was punished? Again, I know where you're coming from, so don't misunderstand me. I have to give you the law. That's what I'm giving you. Okay. Now, if I was looking at it from the point of view of a journalist, I may have a slightly different view. But I'm looking at it from the point of view of a legal educator. So I'm trying to give you what the law is. The law is that you have to exhaust remedies before you resort to any such thing as a sting operation. Okay. So that is the first thing. The second is proportionality. In the name of sting operations, you cannot do something that is more than what is needed to achieve the result that you are seeking. So you cannot do excessive filming, and you cannot also get any result that will be seen by most reasonable people as completely disproportionate. So you have to use tactics or methods that are proportional to the aims that are being sought. And of course, you use sober language in reportage. You may be convinced that a minister is extremely corrupt. Your blood may be boiling, but you don't use abusive words in your report. You may even find it difficult to resist using abusive language, partly because the fellow does something so outrageous, and partly because he may even have, at one stage, been very rude to you. So here's your opportunity to get your back on him. Now the slightly older among you might remember this happened, I would say, about 25 years ago. Arun Shourie, who of course has the reputation of being a crusader for probity in public life, when he was editor of the Indian Express, there was one occasion when he was investigating corruption on the part of a Chief Minister of Haryana. And this fellow was, apart from being corrupt, also very uncouth and used extremely rough language. And what Mr. Shourie did in the course of his report for the Indian Express was reproduced verbatim certain tape recordings of conversations with the minister. And the minister was very liberal in his use of the Hindi equivalents of 4-letter words. Okay. Now, this for a family newspaper was shocking. Now, a question was asked. Nobody doubted Mr. Shourie's intention in doing what he did. But the question was asked, does not Mr. Shourie have any regard for journalistic ethics? Which means that you can make the same point. You can say, Mr. So-and-so, I think there was a fellow called Bhajan Lal at the time, said, used very, very bad language in conversation. Why do you have to reproduce those terrible words? That's the point I'm making. And I personally think, I know that this may not work in India, but in many countries, the more sober you are in the use of your language, the more effective your journalism is. You can be very punchy while still using sober language, while still sometimes you're using elegant language. But I know this doesn't work everywhere, so I'm very willing to accept that sometimes you may have to sensationalize what you're writing. But in ethical terms, it's always a good idea to present your report in sober language. And then, of course, there should be absence of malafide. If you are going to do a sting operation on someone and you have a grudge against that person, that would clearly vitiate your sting operation, because malafide is something that should never be part of the equation. You have to do what you're doing in good faith, without any malice. And this happened in the case of Uma Khurana. I don't have the time to go into it, but you probably know that this case, a school teacher was accused of sexual abuse, of child abuse. And then it turned out that this was nothing but a vendetta on the part of journalists. So again, you need to be very careful. You should cooperate with the authorities post-exposure. So suppose you carry out a sting operation after going through all the processes. After you carry it out, suppose the Central Vigilance Commission comes to you, hypothetically, and says, you published this and we want to now investigate, will you cooperate? You have to cooperate. You have to, for example, give such footage as you may not have shown for legal reasons as part of the sting operation. So when you do that, then your journalism will be more credible than if you said, no, we will not cooperate with you. And that is again something which journalists need to keep in mind. And you should of course avoid damage to the interests of innocent parties. So if you are doing a sting operation on, say, a footballer who is accused of taking bribes, throwing matches, you get an opportunity to interview you want to switch it off? All right, okay. To interview the footballer at his home, pretending to be something you are not, and you use a hidden camera, the footballer, and you ask him questions indirectly which will give you an idea of whether he was corrupt or not. And while you're doing this filming, the footballer's 3-year-old son is with you. You should avoid, as far as possible, exposing the 3-year-old son in your sting operation, because the child has done nothing wrong. Now, of course, if you've got a hidden camera, it's slightly more difficult, but what you can do afterwards is either Photoshop, take out that image, or at least pixelate it, so that the child is not exposed. Your target is a footballer, not the footballer's family, because the family has done nothing wrong. So again, that's something which would be a very important principle to follow when it comes to sting operations. Okay, any questions at this stage? Yeah. Why don't you come forward? There's so many seats here. You sit as if you're technicians. Come forward.
ICC judgment affect the functioning of sting operations, considering now everyone who would be filmed would probably have a right to say that their privacy is violated?
Very good question, to which, if I have to be honest, I will say I don't know the answer, but I can speculate, and I will speculate. The judgment as it stands is sufficiently vague and sufficiently flexible to allow a degree of interpretation. Quite frankly, I think the judges themselves, at least some of them, have said that everything will depend on the facts of each case, that the judgment can be interpreted. Secondly,
So which judgment has been written?
this one, the big one. Okay. Now, the judges have also indicated, and this is where the difficulty arises, that the right to privacy, according to that, is an emanation of not only Article 21 of the Constitution. I'm assuming you're a law student rather than a journalist, right? So you know what I'm talking about. Okay. It's not only Article 21, but also other articles in Chapter 3. Now, as I was telling some of you before you came in, the difficulty is this. Different fundamental rights have different permissible heads of restriction. Now, if you say it's 21, 21 allows for certain heads. If it's 14, it allows for something else. If it is another part of Chapter 3, it allows for different heads. What heads are you going to use is not clear from the judgment. This is a major infirmity of the judgment. Because if you're going to give an authoritative pronouncement, you at least make sure that what you say has very clear guidelines. So, given that uncertainty, I don't know how it's going to play out. But if I was a media person, I would do everything possible to argue that sting operations would still be permissible even after this judgment. Because there is enough indication in the judgment itself that reasonable restrictions can be imposed on the right to privacy. And I would argue that one important reasonable restriction that can be imposed, or one head under which reasonable restrictions can be imposed, would be detection of crime or investigation of crime. Although interestingly, as I was saying earlier, the court does not refer to detection. It talks about investigation of crime. That I don't know whether it's deliberate or otherwise, but I would argue, if I was a lawyer for one of the media organizations, I would very strongly argue that sting operations should still be permissible. So that's, if you like, a longer answer to your question. Okay, right. Anything else here?
So going back to the breach of confidence thing, often what happens is a person in a position of authority would tell us something which probably he or she is the only source we get to know from. But then goes on to say, do not write this.
Yeah.
So if we write it, an example on a bigger scale would be 2-3 years back, a thing happened. The Chief Justice of India was meeting the accredited Supreme Court journalist in his residence, where he made some comments about Narendra Modi, how he was trying to block the collegium system, how government was trying to interfere in judiciary.
This was Thakur.
Yeah, yes.
Okay. Yeah.
So some newspapers reported it, some didn't report. So there was a debate where something saying
About the ethics of reporting.
But
Yeah.
is this breach of confidence?
Okay, it depends on many things. For example, what was the occasion on which journalists were invited to the Chief Justice's home? So if it was even semi-formal, that the Chief Justice invited the journalists, knowing full well he's talking to journalists as journalists. One, it's important. I know it sounds a little trivial, but it is important. Secondly, at the start of the conversation, was any hint given or any explicit statement made that the conversation is meant to be off the record?
That is what the journalist reported, cited. The Chief Justice never told them to not report.
But that's the point I'm making. So you have to find out whether that happened or not. That is a factual matter. That's a matter of evidence. I don't know. I'm just giving you step by step how you go about it. So if it was made clear that the conversation is off the record, ethically the journalist should not reproduce any part of the conversation. Thirdly, if the Chief Justice had not made it clear that it was off the record, then the question that we asked is there overwhelming public interest for this matter to be published? In other words, is it, for example, something that would be considered by any reasonable person to be in the public interest? And I would suggest it is. But if on the other hand the Chief Justice was engaging in gossip while you were all sitting and talking about the sex life of a minister, that would definitely not be in the public interest. So there are so many considerations coming. It is a mix of law and ethics. It is not pure law,
It is
not
not
pure.
understanding and perception, I think.
Sorry?
It is an understanding and perception of the journalist and the Chief Justice or whoever it is. Because in many cases, we never report. This is our understanding that they should not be reported. There is no clear-cut instruction that you should not report. This is the understanding that you should not report. This is understanding and perception, I think.
It can be, but that is not a very satisfactory basis on which to have a conversation of that sort. And secondly, if you leave it like that, then different journalists will have different perceptions or different understandings.
Yes, yes.
So there will be that issue as well. Actually, I think in those circumstances, if you were really conscientious, what you would do is, you would actually ask the Chief Justice, look, we had this very interesting conversation, we are very grateful to you for telling us what you've said. Incidentally, would you mind if we did report on some of the conversations? Which parts of the conversation would you like to be off the record? I don't personally see anything wrong with that at all. It will avoid all kinds of problems later. And remember as well, if you went ahead and published something which was intended not to be published, you are never going to continue to enjoy the confidence of the Chief Justice. You will never be given even innocuous information for the future. I'm not saying therefore that you should curry favor with the Chief Justice. That is wrong also. I'm simply saying that in circumstances where it is not clear and where the public interest is not overwhelming, then there's no harm in your finding out what the status of the conversation was. Okay? Right. Any other questions? No? In which case, let's move on. Okay. This is interesting, but I do not have the time to go deep into this because we have more important things to discuss. What happened in 2007, in this case, which was court on its own motion at the stage, and I've given the date of the judgment, is that the Delhi High Court issued certain guidelines on sting operations. Now, how shall I put it? Read the guidelines, see what you think about them. I personally think most of what they have said is most of what they have said borders on the unrealistic. Okay, and I personally would be aghast if this was made the law. Fortunately, the guidelines. So I think there is a certain room for interpretation. This is what happens when you have judges who are not particularly careful about the consequences of what they say. It is a pity, but there we are. So, and it's very long. That's why I also don't want to deal with it. But you will get the slides so you can read them, and actually it's also online, so very easy to find out. It's just unbelievably bureaucratic and self-defeating, I might say. Just see, this is all part of the guidelines. If we were to deal with each of them, we'll be here for at least 6 or 7 hours. Okay, now I want to go to cases, which is where you get better guidance on all the principles I've been talking about. So, let's take 2 cases, which both are English, but which still have a relevance to India. The first is a case where the footballer Gary Flitcroft, about whom I'm sure you've heard, he was having an affair. And a lot of these cases involve celebrities having affairs. Now, what he tried to do was that he went to court and tried to get an injunction against the publication of the story. Very common tactic, and these celebrities, footballers in particular, have very deep pockets, so they can employ extremely expensive lawyers and try to get injunctions. Now, what the court said in this case was, that and his argument was that his right to privacy is being breached. And I'll tell you, once you begin to talk about the right to privacy being a fundamental right, etc., there will be lots of people who will try it on. You know, particularly people with deep pockets, so they'll go to court. Believe me, there's huge potential after this judgment for litigation to increase in India as well. So this footballer attempted to get a stay. You know why? mainly because he didn't want his wife to know that he was having an affair. But then he dressed it up as a matter of high moral principle and said, my right to privacy is being breached. At which point the court said that the revelations related to extramarital relationships and not to those within marriage. So if on the other hand the allegations were, or the story was about something in his own marriage which was salacious, then probably you would have got an injunction, but not when he's having extramarital affair. In other words, what the court was saying was, if you went ahead and carried on an extramarital affair, then you also have to pay the price for it in terms of publicity. And you can't then talk about freedom of or right to privacy, because freedom of expression is just as important. Now, having said all that, it is not as if the tabloid newspaper, the Sunday People, was particularly altruistic in its own intentions in publishing this story. They also had in mind the fact, the prospect of the circulation figures going up. But anyway, the balance had to be struck between freedom of expression and the right to privacy. And in this case, the English court, held that the balance should be in favor of freedom of expression rather than in favor of the right to privacy. Remember, in the English context, what happens is, we are bound by the European Convention on Human Rights, which has now been translated into domestic law in the form of the Human Rights Act of 1998, which means that there is a strong right to privacy provision in the convention, which is now part of British domestic law. Against that, you have Article 10 of the convention, which deals with right to freedom of expression. Yes, you had a question.
So in this case, you are exclusively of the fact that this was an extramarital affair and not. So, but why would extramarital affairs constitute public interest right? Isn't that still a part of the private life itself?
Well, not public interest in the sense in which we discussed it elsewhere, but on the question only of the injunction. It was a very technical issue before the court. The court said that really what we are talking about is whether in England, in the UK, freedom of expression should be given a greater value than someone trying to hide his extramarital affairs. That was what it ultimately came down to. Now, I have to tell you also that there's a huge divergence in the approach taken between English courts and European courts. In Europe, the position is that you can only do things which the law allows you to do. Whereas the position under English law is you can do anything except those things which are prohibited by the law. There's a massive difference in the two approaches. You may not be able to appreciate it quite so easily. But if you did something in England, the question that will be asked is what you did prohibited by the law? If it is not, you've done nothing wrong. But in Europe, the question that will be asked is what you did allowed by the law? Show the provision of law that allows you to do it. And only if you are able to show the law that allows you to do it, you will not be punished. So that difference is quite important. Now, let's take the second case, Theakston and GIAN, where what happened was, again, there was a celebrity, in this case, the presenter of a children's program, or not children, youth program, who went to a brothel. Now, by itself, not a matter of any great moment, but what he then did was he tried. When he was in the brothel, somebody took pictures of him inside the brothel. Not, I might add, in what the Indian newspapers usually refer to as compromising positions. Nothing of that sort. Just that he was shown inside the brothel with probably one of the people who inhabit the place. Now, he tried to get an injunction against this, and the court said no. The court allowed the story to go ahead, but not the pictures. What the court said was, there is a public interest in the story because this man is a role model for many young people as the popular presenter of a very, very watched TV program. And if he does something like this, there's nothing wrong in reporting that fact. But there was no justification for the photo to be published, because that would be going too far. In any case, you can make the point, the press can make the point, that he did not behave as well as people in his position would be expected to behave. by writing the story, but not by publishing the photograph. So again, most people would consider this to be a sensible view of
So, but
addressing
how
the problem.
is a matter of personal, like he's doing something personal, how is it of public interest?
Well, it is possible to take the view that visits to brothels are a purely personal thing, nothing wrong with that. But the court, and I think English society generally was of the view that a person who's a role model, a celebrity who goes out of his way preaching good things to children, that this is how you should behave in society, etc., then doing the opposite in his own life, deserved to be brought to public attention, if you know what I mean. Now, if he was not a celebrity, if he was this ordinary person who went to a brothel, probably that ordinary person would have been able to get an injunction, probably. But here's a role model, and I think role models matter in society. So, if for example, you have somebody who preaches family values, not a television presenter, but anybody, a politician who goes on public platforms talking about family values, and he has an affair, that would definitely be a matter of public interest, but not if somebody who doesn't preach family values at all and has an affair. They would probably argue that it's none of your business. It is something I'm doing in my private life. Okay? Many of these things are subjective.
Don't you think it's very subjective, as in, just to reflect the point that you made. Now, if this person was not a role model for children, assume this person was simply a film star or a politician who had nothing to do with being a role model for children and teaching them social values and all that. Would such publications still be in public interest?
No, not necessarily, because if the person was an older person who did not present children's programs or anything like that, he was like any celebrity doing things that many people do.
So, assuming the captain of the English cricket team goes to a brothel,
right?
It may be of terrible public curiosity that he's going there, but would the same standards still apply?
I would be surprised if they did. No. You go back to the principle that I have mentioned many times, including today when you were not here. Simply because something is interesting to the public does not make it a matter of public interest. That is the point. It would definitely be interesting to the public to hear about the English cricket team captain going to a brothel, but doesn't make it a matter of public interest. So there are issues like that. But if on the other hand, the captain of the English cricket team, who had published many photographs with his family, showing that he's a family man, and he carried on affairs, then that would be a matter of public interest. So everything depends on the context. So this is mainly because he was a presenter of children's programs that the court took the view it did. Now it's equally possible that another court may take a different view. So that's where judicial discretion comes in, up to a point. Of course, ultimately guidance can be given by the Supreme Court. Now, I want to deal with this case which is extremely important, the case of Campbell. The Campbell I'm referring to here is someone whose name you definitely have heard, which is Naomi Campbell, what is sometimes referred to as a supermodel. Now, what happened in the case was that she was suspected for many years of being a drug addict, that she was taking drugs. And every time the media asked her about whether she was taking drugs, she would flatly deny the allegation and say, I have nothing to do with drugs. But the suspicion persisted. And remember, our tabloid press is quite tenacious in the way that it deals with these matters. So on one occasion, one of the tabloid newspapers got information that Naomi Campbell was attending a meeting of Narcotics Anonymous, which is like Alcoholics Anonymous, except that it's for recovering drug addicts. Now, what the newspaper did was it positioned a journalist and a photographer, particularly a photographer, outside the venue of the Narcotics Anonymous meeting, which was in a building on a certain street. And because they had advance information about when Naomi Campbell would be attending the meeting, this chap waited, and when she was about to enter the building, the photographer took many pictures of her entering the building. the newspaper also got information about what was discussed at the NA meeting. Obviously from an inside source. Somebody was part of the meeting, not Miss Campbell. They then took pictures of Naomi Campbell coming out of the meeting. Again with the building in the background and she coming out. And when she came out and everything was done, the newspaper contacted her and said, we have information that you have attended a meeting of Narcotics Anonymous, which means that you're a recovering drug addict, and we intend to publish this information tomorrow. Do you have anything to say? This is an example of, no, exact opposite. Responsible journalism.
Yes.
Right? Now, they asked her the question and she very flatly and vehemently denied what they put to her. So they said, all right, we'll decide what to do. And the next morning, there was a huge front page splash with the pictures of Naomi Campbell entering or leaving the building and many other pictures in the inside pages. And the caption given was, Naomi, I am not a drug addict. Right? Sorry, Naomi, I am a drug addict. Right? Which of course she did not say. But they were so convinced that they had the information that said, doesn't matter, let us sue, we'll see what happens. So they published the information and Naomi Campbell sued. Now, very interestingly, she sued not for defamation, but for invasion of privacy. Why did she not sue for defamation? Because she knew that what the newspaper said is true. But invasion of privacy is what she thought she would win on. And the case went up to the courts. The newspaper very strongly argued that their right to freedom of expression justified publication of this story. And the kinds of information that came in the story was split into the following heads. First of all, the fact that Ms. Campbell was a drug addict. In other words, these were the implications of the story. Secondly, that she was being treated for it. Thirdly, that she was attending Narcotics Anonymous. And there was information about details of the treatment, which was given by one of the other persons attending the Narcotics Anonymous meeting. And of course, there were pictures of her leaving the NA meeting. Now, the argument in the court was, would Ms. Campbell be entitled to a degree of privacy which should have compelled the newspaper not to publish this story? Remember that generally speaking, anybody who is a recovering addict has a right to privacy. Generally speaking. Keep that in mind. Now, do you think Ms. Campbell was justified in trying to get damages for the story that was published in the newspaper? Why?
Actually, what details related about driving life, drug addiction has nothing to do with public or doing any public investigation. So I would presume that it will not be covered by public.
Okay.
So how can a person's medical reasons amount public interest is a question that can be
Medical.
So it's medical, like she was a recovering drug addict, which means she might be under medication. She was going through a medical
Treatment for addiction. Yeah, okay.
So how is that, as he said, part of public interest? And obviously it can constitute one of the most primary, like basic and private rights of a human being.
Okay.
Like their medical details.
Yeah,
So how can that
okay, fair enough. Anybody else? Anybody who has a contrary viewpoint?
Yeah, photograph.
Hang on 1 minute, I'll just take.
So although I believe that she was justified in bringing the lawsuit for a violation of privacy, I do think that that justification is limited to the effect that considering this is an individual in public life, that too a celebrity, it would automatically imply that the threshold for her privacy would be reduced because of her disposition as a public individual.
Okay.
Which is
so the newspaper was justified.
Yes.
Okay.
Yes.
Why did the photographs? Yeah. Yeah, well, what happened actually was, you're right. What happened was, the court had to consider many aspects of it. There is one thing I forgot to tell you, or deliberately did not tell you, and that is that, because I thought it's implied, is that if you know Naomi Campbell, which I'm sure most of you do, then you also have to recognize that she also was a role model. She was a role model in particular for young black girls, because not many people in her position had risen to that level of fame and success in the modeling profession. So in those circumstances, for her to be a drug taker and to repeatedly tell a lie that she had anything to do with drugs meant that she was being hypocritical. So the allegation of hypocrisy, which was implicit in all the reports, is an allegation worth keeping in mind. But what the court did was, the court looked at these 5 factors and said that it was entirely okay for the newspaper to have published the first 3. The last 2, no. Details of the treatment, no, for the reason that you said, the medical thing, health thing and all that. But also the photographs. Now the trouble with the photographs is this. Actually, details of the treatment, let's take it. First of all, it's her privacy, but also it invades the privacy of other people inside the meeting, because they did nothing wrong and they are ordinary people. They were not hypocrites or they were not celebrities. So in those circumstances, that was not allowed. Secondly, for the photographs, the problem is, remember, Narcotics Anonymous, by its very nature, by its very definition, is an organization whose presence should not be advertised, or at least its physical location should not be advertised. Now, by taking pictures of that building, everybody who reads a newspaper knows where the meetings of Narcotics Anonymous take place. So people who would otherwise want to attend these meetings will be deterred from going to those meetings, which is not in the public interest. So that piece of information should also not have been published. So in a sense, it was a partial victory for the press. And Ms. Campbell, of course, had her drug addiction exposed as a result of this publication. And so it's a very important part of the entire repertoire of privacy cases. So, yeah.
One thing, this obligation of medical treatment details. Often what happens is in a city level, like there's a law and order situation, police and some parties have clashed. So maybe there are bullets, lathi charge injuries. So what we do while writing the story at the day's end, we call up the hospital, the doctor is meeting, and then ask for what is the status of the people who are admitted.
Yeah.
So those are very, I mean,
innocuous pieces of information. Yeah.
What can head injury, fractures, so those things can be published. Is it also?
Sorry, do you ask the cops or do you ask the doctors?
Doctors.
Okay, at the hospital. Yeah. Okay. So
publishing this,
yes.
Is also breach of privacy?
Generally speaking, no. In fact, if anything, there's a strong public interest because it will show the extent to which the law and order situation had deteriorated. For example, if it was a case that 50 people had been injured, all of them with skull injuries, which means that there must have been police misbehavior. Everybody was beaten on their head. So I would say there is a public interest. But if on the other hand, what you reported was some private issue, health issue concerning, say, females, gynecological details, that of course will not be justified. So everything depends on the context. Okay? Any other questions? No? Let's move on. So now, continuing our discussion of Campbell, what happened here was that the court advanced the law. Now, this is more of interest to our law students rather than to the journalists, and you'll have to bear with me as journalists when I explain this. Because this is important. This is how the law of privacy has developed in the UK, and I hope it will develop likewise in India, because ultimately these are the cases that will have to be dealt with by subsequent courts, unlike the Supreme Court, which only gave broad guidelines. Now, what the implications of Campbell are that there was an abandonment of the circumstances imposing a duty of confidence line, which, as you said, as I was telling you earlier, is an important was an important aspect of breach of confidence. Now, they're changing the approach slightly. So what they're saying is, you look at these factors. There was no prior relationship between Ms. Campbell and the photographer. Remember when I spoke about breach of confidence, I said it depends on the prior relationship. There was no prior relationship at all. They did not know each other, and yet a confidential relationship was implied. there was no agreement between them. There was no communication between them. And there were no external indications of expectation of privacy. So, for example, the building did not say, no photography please. So, in that sense, the photographer was justified in taking a picture. And yet, he should not have published the picture. Why? Because there was an expectation of privacy, even if there was no notice that photos should not be taken or published. And then there was the establishment of a private information test. The essence of the tort of invasion of privacy is better encapsulated now as misuse of private information. So what they said was, in respect of those pieces of information which should not have been published, there was a misuse by the media of the private information that they had gleaned through those sources. And of course, we have the clash between Articles 8 and 10 of the European Convention. Now, again, just expanding a little bit, the private nature of the information, namely the treatment for drug addiction, alone deemed sufficient to enter a finding of Article 8 breach. So, the court is now moving from a standard of confidential information to private information. And so that again is quite important, because what they say is the nature of the information about the treatment is itself private. Any reasonable person would consider it to be private. So they signal the move away from protection of confidential relationships to protection of private information. And of course, they transform the breach of confidence action into one for the protection of information that is deemed private. So Lord Hope, for example, has said if the information is obviously private, the situation will be one where the person to whom it relates can reasonably expect his privacy to be respected. So there's an expectation of privacy test which is now being applied. Now, does the fact that the act complained of took place in a public place necessarily destroy any expectation of privacy? Remember, the building was in a public place. This was not, the photograph was not taken on private premises. And the answer is no, as long as the information is of a sufficiently sensitive nature. That's what gives it the character of private information. And the first hurdle that is to be crossed is there a reasonable expectation of privacy? And on the part of people who attended the Narcotics Anonymous meeting, there was definitely an expectation of privacy. And that's the reason why the court held as it did. Also, weighed the competing rights with intense focus on the facts of each case. Again, case-by-case approach. Is any countervailing consideration of public interest justify any intrusion into the individual's privacy? The answer is yes. In the case of Miss Campbell, it was her hypocrisy and the fact that she was a role model. Those were the countervailing factors. And there cannot be any duty of confidence in trivia or useless information. So what you're talking about should be substantial information. And the extent of the intrusion, where justified, must be proportionate to the public interest being served by the disclosure. Again, proportionality as a test is seen as vital. And generally speaking, political speech will enjoy greater value in the balancing exercise in gossip or tittle tattle. When I said political, party political, public affairs speech, speech involving discussion of public affairs. And publication of visual images may be justified, but not necessarily every gory detail of what is being exposed. Again, pictures can be published, but you don't have to show very salacious details or gory details of pictures. That's a matter sometimes of judgment. Douglas and hello. You will have to bear with me for another 5 or 10 minutes, okay? Partly because we started very late, and so I hope you don't mind. This is an important case as well. It proceeds on a different footing. You are probably aware of who the Douglas here is, or the Douglases here are. Michael Douglas and his wife, Catherine Zeta-Jones. Now, when they got married, they had a bash in a hotel in New York. And what they did was they entered into a transaction with a magazine called OK, an intellectual heavyweight, which, under the terms of which, the Douglases were to be paid $1 million for exclusive pictures of the wedding reception. Now, what that meant in practice was that no wedding guest could take any picture of what was happening. Nobody could take any picture except the approved photographers of OK magazine. And not surprisingly, if you're going to pay somebody $1 million, you're going to protect your interests very strongly. So what OK magazine did was to subject every guest who attended this event to the humiliation of having them frisked thoroughly. Every mobile camera, every phone was taken away, and they thought they now have a camera-free zone within the party. They were completely mistaken, because somebody inside did manage to take a lot of pictures, and what that person did was sell those pictures to a rival intellectual magazine called Hello. And Hello, of course, made hay, because these pictures, believe me, sell magazines in a big way. The fact that a magazine was willing to pay $1 million means that they would have made profits which are multiples of that sum. So there's a lot of money there, which some of us naive people may not understand why there is, but that's the nature of public interest in this, or interest of the public in these matters. So Hello went ahead and published those pictures. Now obviously OK was not best pleased. But there's a problem here, because there was no legal connection between OK and Hello. Because in law, there's the concept of privity of contract, which some of our legal friends will appreciate. So that would have been a hurdle in suing. And yet, they wanted to do something about it, because they can't lose $1 million just like that. So the lawyers got together, they scratched their heads, and they decided anyway to sue on grounds of breach of privacy. And because we are running short of time, I'm just going to quickly tell you what really happened was the judgment effectively said that Hello was wrong in doing what it did, because it should have known that there was a relationship of confidentiality which was being breached by the fact that these pictures were unauthorizedly allowed to be given out. So for that reason, the Douglas's and OK magazine were compensated in this particular scenario. Now, just a few findings. Privacy protection is not reduced by the plaintiff's decision to sell the information in question. In other words, it's not only high-minded acts that qualify for privacy protection. Even situations like this, where they sell information for money, would be protected. And photographs are not merely an alternative method of conveying information, but have a value of their own. Again, this is a legal finding which some of you may not immediately appreciate. And an injunction is an appropriate remedy in such cases, and it will be more appropriate to call such actions misuse of personal information rather than breach of confidence. Again, you're moving from the standard of breach of confidence to something called misuse of personal information. A couple of other cases. In fact, what I'll probably do is, I'll skip the second one, I'll tell you about the first one, which is probably more practically useful. The pet case involved a young man who was very mentally disturbed and mentally agitated, and he decided to kill himself. But he did it in a or he decided to do it in a public place. So what he did was he ran around in a city center with a knife. Somebody saw, you know that nowadays city centers are full of CCTV cameras. The authorities saw him about to commit this act, and they prevented it. So they stopped the suicide. But of course, there are all the images of him running amok with a knife. And after a few days, it turned out that the CCTV images were were given to a local TV station. And the local TV station played this. As you know, sometimes in India as well, you see something being repeatedly played. And this led Mr. Peck, the young man, to be very upset. So he sued the TV company on the grounds that his privacy had been invaded. The case obviously involved Article 8 of the European Convention, and the case went to the European Court of Human Rights. And the verdict was that the display of the material is not justified, the person's identity is not masked. In other words, that even in a situation like this, this happened in a public place, and yet there was an expectation of privacy in such matters, because it's a very intimate thing for a person when something like this is filmed and shown. And it was said that in the European Court that English law was not sufficiently strong to protect a person's privacy interests. I'll leave it to you to look up that other case. Max Mosley. Okay, this is a case. I'll again summarize it. I'll be very brief. It involved a man who, incidentally, Max Mosley is better known as the owner of Formula One. Okay, he's a lawyer, he's a barrister by training, but he became more famous as the owner of Formula One. He's also known for another reason, and that is he is the son of the fascist leader Oswald Mosley, who in England was notorious for a short while.